The Big Small Business Show is proudly brought to you by Syca. Choose a difference maker, choose a chartered accountant.
The Big Small Business Show, proudly sponsored by MTN Business.
Welcome to the Big Small Business Show, the show for all our entrepreneurs out there who are trying to make it through each month. And sometimes, in fact, too often in our entrepreneurial journey, we have to meet with these guys called lawyers because they either have to keep us on the straight and narrow or somebody else is trying to keep us on the straight and narrow. And so we need our own person to protect us. And in studio with us today, we've got Rui Marto. He's director, Marto Lafitte Associates Inc. And he's here to talk about the illegal stuff that's important to us as entrepreneurs. Welcome to the Big Small Business Show.
Thank you so much, Allon. Thank you for inviting me.
Right, so we're going to start off with the shareholders agreements. What I see often with entrepreneurs, especially ones that have got together early on, in other words, they haven't brought in a partner later on in the journey, is that two mates, they get together, they got an idea, everything goes okay until it doesn't go okay. Or actually the opposite happens, is it really goes really well. And then things don't go well after that. And then they look for this document that regulates it and it's not there. And then the proverbial happens. So let's talk about shareholders agreements and tips for our entrepreneurs out there, specifically if they haven't actually got one in place right now, what do they do? And if they are putting one together, what do they need to do?
First of all, let me just say how crucial it is to have a shareholders agreement. And I know that when people start out, I know that entrepreneurs, there are a number of items which are all competing for that budget, which is pretty tight. You know, the shareholders agreement really sets that blueprint in respect of how your company functions. It confirms really the shareholding, the structure relating to the shares, the meetings, how it operates, the operations between the shareholders, and it really has crucial aspects in respect of how the business is going to run. And so without it, of course, it can lead to immeasurable conflicts which aren't necessarily foreseen in the beginning. And as you say, in the beginning, you know, you talk about usually the material points, those two friends that go into business together, they talk about, look, you do this, I do that, let's go into business together. But then if you're not sitting down with the shareholders agreement, you don't go through the number of items that you can't even think of. What happens at death? What happens in respect to forced sales? What happens if you want to sell and I don't want to sell? And all of those things, that should be governed by then the shareholders agreement.
And what I see as well, Roy, is that entrepreneurs then, watch this and then they go onto Google and they download or go to ChatGPT and they download something, which is quite American, that won't stand up in court here. And I've seen that often where I get involved in businesses and I say, is there a shareholder agreement? I look at it and it's really some templatized document that is actually quite useless.
Well, I think while certain things are universal, it will be very rare to find that one of those templates fit exactly in terms of what it is that you require. Because let's face it, no two businesses have the same requirements. And certainly no two shareholders necessarily have the same requirements. So it's important to get it early on. And ideally, you want to have that shareholders agreement set prior to opening the business before you get going. Because that's the time where you can then have a chat about all these different aspects that we've been speaking about. But also it's important to have it bespoke. It has to be tailor-made to your specific requirements.
Let's go through some of the important points within that shareholders agreement. I mean, you spoke about some on death, like forced sale, etc., preemptive rights, those kinds of things. What should all shareholder agreements have in them?
Well, I think the crucial aspect relates to, one is in terms of shareholding. So who owns what shares and what those voting rights look like. Don't forget to take voting rights. There's two aspects I think that are important. One is if you are, for example, a majority shareholder in a company and each shareholder gets to appoint one director, You can potentially dilute your shareholding if you have a provision, for example, that each director only has one vote. So suddenly your 70% shareholding is equated to 50%. So those kind of aspects relating to the voting rights and weightings are crucial. The second aspect, with respect of minority shareholding protections. So if you're a minority shareholder, on the other hand, then there are certain decisions which you want to have protections. Now, the Companies Act does have protections for minority shareholders, but that might not be sufficient.
What is a minority shareholding? Is 25 or less?
So minority shareholder is really in relation to the other shareholders.
Okay, so it's not necessarily less than 25%.
It's not. It's in respect of less than any other majority shareholder.
Okay.
So, but in that instance, you want to make sure. So, if you don't have the voting right, the majority voting right, then you're going to want to be protected. That in respect of certain crucial decisions, you're going to want to also have a say, and that includes aspects like declaration of bonuses, dividends. Salary increases, for example, maybe even hiring and firing. And that's what I mean in terms of being bespoke, is that there are certain things that might be crucial for you, which might not be crucial for another business. So in that regard, minority shareholding and voting rights are also become very important.
I also see often that conflict happens when the business needs funding. One shareholder has money, the other doesn't, and there is a rights issue. In other words, either you put in your money and follow your rights, or you get diluted.
That's right. So those would really fall under the forced sales provisions. And it's important to have that discussion beforehand about funding, exactly to try and prevent or whether you can enforce those provisions. So you can set in your shareholders agreement how the company is going to be financed. You could say the first round is in relation to from shareholders' loans. Your second round must be in respect of lending from financial institutions. And those can all be set exactly to try and avoid a situation where a financier dilutes the shareholding of shareholders that can't afford to put money in.
The other place where I see a huge amount of conflict is where a shareholder wants to leave the employment of the business but keep their shares.
Yeah, so I think it's always important to see those two together. So when I give advice on employment contracts, especially if they're shareholders, you should have provisions that link the two, where either you can allow it if people are comfortable with that. Alternatively, if you leave as an employee, you must also then sell your shares.
Okay, I think that's a good place to take a break. And when we come back, we're going to actually talk about employment contracts, both with your employees and with you as shareholders or directors of your own business.